All right. Thank you, everyone. And thank you for your patience and for joining us today for this Reframing Retirement event. And today's topic, estate planning do's and don'ts, presented by Luke A. Johnson, PLLC, attorney at law. We want to thank the Pikes Peak Area Agency on Aging and Ent Credit Union for collaborating on this series. Before we begin, we ask that you please keep your microphones muted. We also ask that you can rename your profile so we can actually call out the correct person during our question and answer portions and for the door prizes at the end of the series. At the end of the session, excuse me. You can also use the chat area to let us know when you have a question. And now it's my pleasure to introduce Pamela Hogard, Case Manager at the Pikes Peak Area Agency on Aging. Pamela, it looks like you're muted.
Well, there you go. Good afternoon, everybody. Thank you for your patience in our technical difficulty this afternoon. This is our 9th series on retirement, and as indicated earlier by Jared, we have partnered with Ent Credit Union for this dynamic series, and we hope you enjoy the topics that will be presented throughout this series. Nate Juvera joins me today in representing Ent, and he will provide a few words later in the program. As Jared mentioned, my name is Pamela, and I represent the Area Agency on Aging. We are a resource agency specializing in older adult information, assistance, public education, and publications. The Yellow Book, to name one, the Veterans Benefit and Medicaid, another, and also last but not least, we house the State Health Insurance Program, which is a program of unbiased information on Medicare and health insurance. Now, let me just say that we've remodeled our retirement series to reflect what we are hoping to be a more accurate representation of the longevity of life, commonly known as retirement. Now, I should say that it's an outdated term, and it's a script that people have in their minds that it dates back to the 1930s. Well, the life expectancy back in that time was about age 65. Well, however, life expectancy is just under 80 now. So what we are experiencing is longevity with the possibility of living 20 to 30 more years after the age of 65. So the new mindset that we are trying to help people or to create for you today is to say, what's next? Instead of loss of productivity and purpose and riding into the sunset. So, and the purpose of this series is to help you see what you can create for your next 20 to 30 years. We hope you'll find them interesting and useful. That takes me to our current topic, which is estate planning. We've added a new speaker with us for this season, Luke A. Johnson, and he will be providing you with much needed information about getting your affairs in order. But before we get into Luke's presentation, I'd like to introduce Nate Juvera, Community Education Events Lead, to say a few words about Ent and our partnership. Nate, it's all yours.
Thank you, Pamela. So my name is Nate Javera, like Pamela mentioned, and just to tell you a little bit about Ent before we get started. So Ent Credit Union was founded in 1957. Ent is Colorado's largest credit union and has been consistently ranked as one of Colorado's best credit unions by Forbes. Ent is a not-for-profit financial community chartered credit union and is committed to improving our members' financial quality of life through things like better rates, lower fees, and unparalleled products and services. With nearly $10 billion in assets, Ent serves more than 550,000 members, and we have just about 55 convenient service centers all across the Front Range. Ent is an equal housing opportunity and equal opportunity lender, insured by the NCUA. For more information, you can always visit ent.com. Another thing to mention to you all is at the end of this webinar, we will be giving away a $50 e-gift card to one lucky winner, and that gift card will be something of your choice. So be sure to stick around to the end because you do have to be present to win. So if you stick around to the end, one of you might win a $50 gift card. So with that, I'll pass it back to you, Pamela. Thank you.
Thank you, Nate. All right. Let me take a few minutes just to introduce Luke. He started his practice, trust and estate law, in 2013, and he has worked with thousands of clients preparing estate planning documents and helping individuals navigate this process. In January of 2022, Luke launched his own solo firm with the goal of providing personal and nimble representation using modern legal solutions. And there's a lot more I could say about Luke, and you can continue to introduce yourself, Luke. Join me in welcoming Luke Johnson. Go ahead, Luke.
Thank you. Hopefully my untested audio sounds okay here. I'll look for a head nod or two on that. Excellent. Well, thank you to the Area Agency on Aging, as well as Ant Credit Union for having me. Pleased to give this series a try. I put together this PowerPoint. This is a new first time I've used it. Really the only thing I had to research in doing it was where the apostrophes go on do's and don'ts. That was the first thing I had to figure out. If anybody has any strong opinions on that, apparently it's up for debate, but that's not really what we're here to talk about. We're here to talk about estate planning. So I have some pretty heavy material here to go through, and hopefully I will keep a few of you around so that somebody's eligible for that door prize. But without further ado, I will kind of launch into that. Let me actually get my slideshow started. Okay, I think that did it. So I think the first question to answer is, what actually is an estate plan? In most general terms, an estate plan states what happens to your person and your property when you're unable to act for yourself, whether that is at death or actually whether that comes before death in the form of incapacity. Incapacity planning, in my opinion, not just planning for death, is equally or more important these days, particularly if we're talking about retirement and how to function within that. I think it's particularly relevant to this conversation. The other basic, the most basic thing that you're doing with an estate plan is selecting somebody else to carry that plan out. You're not going to be there to do it for the most part, and you're picking somebody you trust and somebody who's capable to follow the instructions that you're coming up with. There are all kinds of documents that could be part of an estate plan. I've set out a list here. The list could be much longer. There are many subtypes of these types of documents that we won't get into in the scope of a day like today. But just generally speaking, we're talking about wills or trust when we're talking about what happens to your property upon your passing. We're talking about powers of attorney, whether financial or medical. If we're talking about incapacity planning while you're still living. Living wills, generally speaking, are directives, types of advanced directives that gives directions of what you want at the end of life. I've listed some more particular types of trusts here, just to give an example of how many different types of things there are. There's deeds, there's beneficiary designations that you might do, particularly with a financial institution like Ent, for example. And there's also directives as to how you want your last remains to be handled. Do you want to be cremated or buried? Those are just generally the main components you would see in most estate plans. And so I have my first slide here as a definite do, and that's pretty simple. It's do make an estate plan. An estate plan is not ever guaranteed to work perfectly, but it's almost always going to be better than no plan at all. Don't assume that plans are only for wealthy. Anyone with any type of property can benefit from a basic estate plan at least. And you might actually have more to deal with than you think. When you think about life insurance, that's not something that you can access while you're still living, but certainly can be a sizable asset that's part of your estate on your passing. They're not just for the wealthy. And more importantly, medical powers of attorney, in particular, dispositional last remains documents, have nothing to do with your wealth. Again, that's what needs to happen to your person if you're not able to give those directions yourself. So I give that example. I harp on powers of attorney. I've met with folks who really didn't have to have a will based on their circumstances, based on their family and their desires. But I told them they absolutely had to have a power of attorney. And I really insist on that. What you're avoiding with a power of attorney is having the court select someone for you. And that's in the form of a guardianship or a conservatorship proceeding in the probate court, which is not pleasant to go through for yourself. It's not pleasant for the person who's appointed as your guardian or conservator to have to report to the court and keep the court informed on an annual basis, at least, as to everything that's going on with you. So the bullet point again was, don't just assume it's for the wealthy. Some level of estate planning can benefit everyone. And lastly, an estate plan can be affordable and cost efficient. In many cases, a failure to plan or making a bad plan is going to be more expensive to fix later. So it's a good investment to make for many reasons that we'll get into. Don't put it off for decades. This is a definite don't in my mind, and the reality is that most people do put it off. I would say at least half of my clients that come in tell me that they've been thinking about doing their wills for decades, that procrastinated about it and knowing they need to do it and are just finally getting around to it. Procrastination, everybody does it, but it doesn't feel good. And procrastination with some things relates to things that we don't know are definitely going to happen. Well, we know that your estate plan is going to be invoked one day. At some point, you're going to die. Hopefully, in the meantime, you don't become incapacitated, but it is a very real possibility. So planning brings you peace of mind. And all my clients tell me that they feel a great relief when they finally get things done. In addition, I also, and I meant to mention this at the beginning, about half of my practice, maybe a little less these days, is the planning side of estates. But the other half is very much assisting folks through estate administration, helping them to navigate the probate court, if we're talking about probate, or helping them to navigate the trust, telling them what to do. And so the other call that I get is from a relative or a family member when somebody has passed, saying, we don't know what to do. And a lot of times when they cannot find the documents, either because they don't exist or they know that one does not exist, there's a panic. They think the state's going to take everything. We don't know who's going to be in charge. Somebody else is taking charge. And so avoiding that initial panic just by having a document there can be a great relief to your family who's trying to figure out what's about to happen. The other thing that happens if you put it off for decades is you're getting ready to go out of the country and you're going to decide, oh, I'll just write something down so I have something the night before you leave. And there's a couple problems with that. The first one is, and I'll describe in detail the hazards of doing your own planning and how that might produce something that doesn't do what you think. But the other problem with getting in a hurry and writing your own will or writing your own documents is that you don't really have the time to think things through like you would if you undertook a more deliberate process. So even the vacation will is common. When I have folks come in to do planning, I ask them if they have any documents in place, and that's a common answer. Oh, well, we really just have this thing that we wrote before we left on vacation, and usually it's not bringing them a whole lot of comfort because they know they did it in a hurry, and it may or may not be good. So that's what procrastination produces, is some rushed and haphazard planning, and that's not what we're trying to do here. Lastly, if you fail to ever get a plan in place, and I'm speaking specifically here about a will or a trust that governs what happens on your death, then the state will make one for you. It doesn't just automatically go to the state of Colorado in most instances. That is a possibility if you don't have any remote family members. But I wanted to kind of just spend the next few slides showing you what does happen if you don't make a will of any type and you die what we call intestate. So just as a initial observation, I'll say, if you have a very traditional nuclear family, not blended children from prior relationships or marriages, then sometimes it will work out kind of within what your intentions would be. If there's any additional factors, then often it will not work out correctly or in line with your intentions. So this first slide, and I'm not going to go through all these in great detail because everyone would leave if I did. It's really just to display, how complicated it can be. But this first slide here describes what the share of a spouse is. This is in the Colorado statutes. You can look it up if you're really curious. The statute is cited here at the top. But again, this is what happens if you don't have any kind of planning put in place. Colorado says if you don't have any children and you don't have a surviving parent, it's all going to go to your spouse, for example. If you share all of your children with your spouse, all your children are your spouse's children, the spouse is going to get the entire estate. Then here's where it starts to do some different stuff. Let's say you don't have any children, your spouse survives you, and at least one of your parents survives you. Colorado says, oh, maybe this person would have wanted their parent to receive a share, but only if the estate is over a certain amount. So I'm looking at subsection 2 here in my slides, and it says the first $300,000 plus 3/4 of any amount over that first 300,000 would go to the spouse, but the parent would receive anything, essentially 1/4 of anything over 300,000. So that's just an example of where they start making assumptions. The next two relate to if the person who died or the spouse have separate children, and they also carve up the estate, trying to divide it between the surviving spouse and those separate children or the children of the deceased person. It can get pretty complicated. And, as a general rule, it's not necessarily in line with what you would want personally, but it is the legislature's best guess as to what you would want, which is the best that they can do because you didn't do any planning. So that's the share of the spouse. As to the shares of your descendants, I've also listed this out here. This took a full page, but this addresses, again, what surviving parents might receive, how it would be divided between descendants, depending on if any of your children died before you did. As you can see, lots of scenarios here. This is what you're depending on if you don't make the plan yourself. Moving on to the next slide, here's some more legal jargon. This per capita at each generation. This addresses how things go down to your descendants, again, depending on whether or not one of your children passed away before you, whether it would then go to their children. The statutes have all kinds of vocabulary here that applies if you don't do your planning. If you do your planning, we may use some of these same terms. They're not bad terms, but we want to use the ones that you want. We don't want to rely on, again, the legislature's best guess of how you want things to be divided depending on who's alive. So I just, again, provide those to kind of give an illustration of how complex it can be. This next slide here is the sheets that I get every January, sometimes February when they get around to it, from the Department of Revenue. And all those numbers that I just shared with you, such as the 300,000 that goes to the spouse, and then the remainder goes to the parents. Those numbers are not the numbers. So if you go read the statutes, you'll have incorrect numbers. You have to have this sheet from the Department of Revenue that says how they adjusted the numbers each year. So in the case of that first example I gave, where I said 300,000, it's not 300,000 if you die in 2023. It's actually 402,000. So that's the size of the, if the estate's under 402,000 in the scenario I gave you, where there's no surviving descendants, but there are parents surviving as well as a spouse, the spouse is going to get that first 402,000. But anything over that, the spouse is going to have to divide with the parent and give them 1/4, which if a lot of the wealth is tied up in the house, for example, that can be a problem. So that's just an example of something that we use with cost of living adjustments. The other thing that we have to deal with in the context of estate administration, actually, whether or not there is a will, is these things, same things on this page: exempt property and family allowance. Those are requests that can be made by a spouse and minor children from the estate just for support while the estate is ongoing. Practically speaking, those are used at all points for all purposes, but that's about 80,000 in total at this point. I'm going to move on from this and just say this: don't rely on your heirs to interpret the last 4 slides. As you can see, it's highly complex, and leaving it up to them to try to figure it out is not going to be as advisable as at least giving some direction in a will or a trust. They are inevitably going to have to use an attorney at that point to help them decipher all of this anyway. And so if you're putting it off for financial reasons, you're just putting it off, because that's the state of the law, for the better or worse. It's complicated, and it's only more complicated if you don't do some planning. So moving on here, do at least talk with an attorney. I will say that most estate planning attorneys in Colorado do not charge for an estate planning consultation. Now, that should be something that you straighten out when you call someone from the start, but as a general rule, like I said, most attorneys of my type will have you in, have a lengthy talk with you, many times quote a flat fee to complete the work. You're not going to be obligated to agree to that. You can take the information you receive and leave it. Even if you don't decide to use the attorney, I think, like hopefully this presentation will do, you're probably going to gain some helpful information from that conversation. And it's going to make you think about things that you need to think about, conversations you need to have with family that will be helpful whether or not you actually proceed with an estate plan. In the course of meeting with folks, I almost always ask questions that they need a little more time to think about, or that they haven't thought about. And I think having the conversation and engaging in at least the beginning of the process is valuable, whether or not you move forward with that. Next, I'll say, you don't have to overcomplicate or overpay for your planning. I'll call it, unfortunately, there is a considerable amount of fear mongering that can be done. And hopefully I don't sound like I'm fear mongering. As I think about it, this has been pretty negative so far. So, but the point is that there are simple solutions to these issues. You do not have to overcomplicate it, and you don't have to pay a fortune to address the issues. Some estates justify some trust-based planning, and I'll talk about what that means, and some don't. Some estate planners will tell you that almost everybody should get a trust. If you start looking on the internet, you're likely to run into that information. And it certainly can be appropriate for some people, but it's my opinion that it's not appropriate for most people in Colorado. And that's another important distinction. Certainly in some states, it is a good idea for everybody to do a trust, or most people. But generally speaking, a trust-based plan is primarily intended to avoid the court process of probate on your passing. Probate is just the name for the court process that you go through to have the court accept your will, actually confirm the person that you've chosen as your executor or personal representative, and proceed with the administration of your estate. If you put all your assets into a trust, or the assets that are important, and they pass according to that trust document after your death, you're not going to need a probate proceeding to get your estate transferred if everything's done correctly and maintained through the years, and I'll get to that. With a will, on the other hand, often probate will be required to carry out that will process I just described. However, the probate process in Colorado, in my opinion, is very straightforward compared to a lot of other states. I've said here that in 90% of my cases, we're able to use what's called informal unsupervised probate. What that means is that I file an application with the court, which is actually just reviewed by court clerks, not even a judge. They'll stamp it if it's done correctly. And then you, as the personal representative, you have your papers, your letters, we call them, and you proceed with carrying out the will, and the court stays out of it unless somebody informs the court that you're not doing your job correctly. That's the informal unsupervised administration. You don't have to go to court for a hearing to start with. In most cases, you don't have to ask the court for permission to do what you need to do. You just need to keep the rest of the estate parties informed so that they don't go complaining to the court that you're not doing your job. And that's probate in Colorado in the fair share of cases. So that's the main difference between a trust-based plan and a will-based plan, is that with a will, there's probably going to be some process required, some additional process after death. You have to think about whether that's a big deal to you or not. So we'll talk a little more about both of those. I've listed here some good reasons to think about using a living trust. And to describe it in one line, I would say this: a living trust is more expensive and it's more groundwork and maintenance for you during your life. It's usually going to result in less work, and less expense for you after you die. And so think about that. You may not care if you don't want something that you need to maintain to work correctly during your life. You have somebody good to handle things after you're gone. Maybe you don't need to worry about a trust. But that's more the next slide. This slide is, why do you want to trust? Here's some factors. Some very, very large estates, I would call it, may justify some estate tax planning through trust. When I say very large, here's the deal. For 2023, the federal estate tax exemption is nearly $13 million per person. So if you're married, you have $26 million you can pass without paying any estate tax and without paying any tax really on the transfer of your property to your heirs. That's whether or not you have a trust, whether it's a will or a trust, it doesn't matter. But if you do have that much money, first of all, you definitely should do some planning. But second of all, a trust may be justified to help try to minimize those estate taxes. Now that number is scheduled already to go down after 2025. we're expecting it at that point to be around $7 million per person instead of 13. Right now it's doubled through 2025. And so, it's going to go down, but still, I don't know too many people who come to see me who have more than $14 million. So that can be something that justifies some trust planning, would be being above those numbers. You probably can justify the expense of a trust. Colorado, and those numbers are all federal numbers. Colorado actually has no estate tax, effectively, I'll call that. Another trigger would be owning real estate. A house or land is any kind of real estate in multiple states, other states that would trigger probate proceedings in those other states. As I mentioned, probate in other states can be very involved, very expensive. The examples I always use are actually California and Florida. In a lot of cases, they have minimum fees that go to the attorneys, that go to the personal representative or executor. The court gets really involved in administration. It's just a totally different process. And by the time you're looking at doing 2 probates because you own real estate in another state, it can definitely justify just doing a trust to avoid probate in all of those states. So that's always something that would make me want to consider a trust a little bit more. The other thing a trust can do is, while you're still alive, but during your potential incapacity or diminished capacity, it can provide a little more protection for you from yourself. So if down the road you start to experience some dementia and become that much more susceptible to exploitation, the trust can have provisions that take away your ability to hurt yourself, take away your ability to write the check to some made up kingdom in Europe. I've seen it. It happens. And pass that responsibility of protecting your estate on to your successor trustee. If all your assets are in the trust at that point, then you're not going to be able to diminish them. Now, we have some other options with a will, but we're not as able to protect yourself as much with a power of attorney, for example, nominated to handle some of those issues. So the other thing I would say about if you're going to do a trust is you need to be committed, and you should prefer to keep your finances pretty thoroughly organized through the decades, because if you don't keep your trust, your assets titled in the trust, if you sell your home and buy it into your individual name and it's not in the trust, and you own property that's not in the trust and you're passing, then there's a decent chance you're going to have to do a probate anyway, because the items are in your individual name. And that tends to happen through the decades because people will go in and do their planning. They think they're done. They're not staying on top of it. Assets move around. And then 20, 30 years later, you've got a completely different setup and you're going to have to do probate anyway. And the main point of that trust for a lot of people is to avoid the probate, and you failed to do that. So that's one thing I always ask folks and clients who are considering a trust is, are you committed to keeping on top of this? So that's important. I'm going to take just a second to see a couple of chats here, and I'm waiting on questions. And
I think the only question we have so far is, will the recording be available later? And it will be. Yes, it will.
Excellent. All right.
Did you want to take the questions as they come up, Luke, or did you want to wait until the end?
No, that's okay. I just saw the notification up there when I took a second.
Okay.
We can wait till the end. I mean, if people want to go ahead and put them in the chat, that's fine. I think we're definitely going to have some extra time, so should be fine. The next slide here is good reasons to keep things simpler with a will. So in one line, when I propose a will-based plan to somebody, I describe that as generally less expensive and less complicated for you now to put it in place and both during your life. It's going to result potentially in slightly more work for your successors and slightly more expense to your estate after your death. But it is a plan, and it's going to be much better than no plan. As I mentioned, generally speaking, a will-based plan is not going to be as expensive as a trust. You're going to be able to nominate capable folks to navigate probate, and that's important. If you don't have anybody who you're nominating as a fiduciary who you think can handle any kind of court process, you may not. You may want to consider a trust-based plan. You may want to think about some other things there. But if you have capable people who can navigate some court process, some simple probate as I described, then it's not going to hurt anything to allow them to do that on your passing. Another thing to mention at this point, and I have a whole slide on this, is beneficiary designation. So your will and thus probate only apply to your accounts that do not have beneficiaries associated with them. So as an example, if you have just a bank account, that's all you have, and you have your 2 children named as your beneficiaries, on your passing, that's going to go to those 2 beneficiaries before we ever even look at a will. They can go in, they can present a death certificate. We don't need to do a probate. We don't need to do a will. Any kind of beneficiary designation, which I'll talk about in a little more detail later, is going to pass outside of the will and outside of probate. So if you have a pretty simple estate with not too many pieces, it's actually very doable to avoid probate with a simple will without doing a trust. It really just depends on what you have in your estate, how many beneficiaries you have, what types of beneficiaries. Are we leaving stuff to charity or just children, and how complicated we want to get. But in pretty simple scenarios, transferring everything through beneficiary designations will work. And then still you want to have a will as a backup, because inevitably you don't want to rely on having those. You want to have a will as a backup, but that is a way that I have many clients actually set up a plan where we don't expect to need probate, and they don't have to do a trust to do that, because everything's going to go through beneficiary designations that are set up on each of their accounts. Another reason is sometimes I talk with folks a little bit. I see the current state that their finances are in as we go through what their assets are. And I tell them, I don't think you're going to maintain this trust for the next 40 years. It's not going to work like it's designed if you don't do that. And so I don't think you're a good candidate to do a trust and to maintain it. If that's the case, I still want them to do a will, but I don't want them to try to organize everything that if I know it's going to fall apart through the years. So that's another reason I would say somebody to just keep it simple with the will. Okay, so here's a major don't, and hopefully, again, I don't come off as too preachy or fear-mongering here, but I really want to tell you not to do your own documents. Forms are available and abundant online these days. Certainly, I see a lot of documents that clients have prepared themselves, and they are valid documents. They're not invalid because you didn't execute them properly. It's actually quite easy to get valid documents in Colorado because, at least in the case of a will, all that's required is either one notary or 2 witnesses. It can be either or. A lot of folks will do both of those things. That does not hurt, but you only need one or the other, either a notary or 2 witnesses to make it valid. If it's a typed out will, those are the requirements. We do have a third type of will in Colorado. It's called a holographic will. It's fancier than it sounds because a holographic will is actually just your handwritten will. It has to be the substantial parts of it must be in your handwriting. and signed by you, ideally dated. If you scrawl out your own will on a napkin, and I've had a napkin will that I've probated, that's valid. It's a valid will. It will be accepted by the court as a valid will. The problem with wills that folks do themselves is the language doesn't say what you think it means. You've already seen some of my statutes that I flashed up here. And those are just examples of probate law in general. But specifically in the realm of saying what you think you mean and the law saying you mean something else, I spend a lot of time fixing these issues with estates. And that's where you're definitely going to need an attorney to help you out if you have an ambiguity in your document. I've listed a few common examples here. Things that, again, I have experienced. They're common issues with self-done documents. The first one would be something called ademption. So we call a piece of property or a gift to someone in a will a deemed if you have that property when you make your will, but before you die, you sell that property or get rid of it. And so in this example, you leave your home to a specific person, but you sell that home to pay for your care prior to passing. Depending on that person that you left that home to, they could have a claim against your estate for a value equal to your home, which could be your entire estate, particularly if you've spent a lot on your care. Typically, we're talking about that being a relative of yours where that would apply, but the relationship can actually be somewhat remote for that to be applicable. And I've run into several cases where that gift, that non-ademption, which the statute does, actually consumes the entire estate and gives the entire estate to a person who was not supposed to receive the entire estate. But the document didn't say what was supposed to happen if you didn't have that home on your passing anymore. So that's an example of contingencies that a lawyer would think of that you may not think of if you're scrawling out that document the night before you leave for Spain. So that's just one example. Another is leaving a amount to someone who dies before you do. So the other thing that the law assumes is that if a person is somewhat closely related to you, and a nephew would count in my example, you leave $25,000 to your nephew, and your nephew dies before you, but has two children you've never met. Those children are going to receive that nephew's $25,000. Unless you say in your document what's supposed to happen if he doesn't survive you. So these are examples of things that I definitely address when there's any kind of specific gift, because the law does weird stuff, makes assumptions if you don't state what you want in your planning. Lastly, another common example is leaving specific dollar amounts. I usually encourage people to leave percentages of their estate for this reason, but anytime you talk about a specific dollar amount, that's usually going to come out of your estate first. And so the problem that you run into, particularly if your estate does not have as much as you expect on your passing, is that when that money comes out first, you might leave it to a nephew again, and then the remainder of your children. The remainder is supposed to go to your children. If there is no remainder, that nephew is going to get the $50,000. The person who gets the specific amount gets the $50,000. Those pay out first, and children will receive nothing. I've seen that play out as well. And so again, if you're doing planning with someone like me, I'm going to A, discourage you not to do necessarily a specific amount, or B, some kind of language that's going to address that contingency of $50,000, but not to exceed 10% of my estate, something along those lines. So again, the point of that whole discussion is to say, you do your own documents, you run the hazard of saying something that you didn't mean, not addressing a contingency that could result in unwanted results. I mentioned this before, just briefly, but I ended up coming back and making my own slide for this very subject. But you should understand beneficiary designations. Most financial accounts, such as a checking or savings account, a brokerage account, an investment account, your retirement accounts, your IRAs, your 401ks, pretty much any kind of financial account these days will permit you on that account with that financial institution to designate a beneficiary with that institution. Now, they have different names for it. Beneficiary designation is kind of a blanket term. In many cases, banks will call it pay on death. Brokerages will call it transfer on death, but it's essentially with a specific institution listing a beneficiary to receive your account on death. If you do that, that's going to take precedent and override whatever you have in your will or even your trust potentially. And it's important to understand that, because if you come in, you do a will with me, and you say you want things divided equally between your children, but on your bank account, you have one son named as the 100% beneficiary, it's never going to get to the will. It is going to go according to that beneficiary designation. It's going to go outside of probate to that person, and they may carry out your intentions. They may do the honorable thing that they know you would want. They may not. They may be under circumstances that you didn't anticipate. They might be going through bankruptcy or in the middle of a divorce, and they're not going to be able to do what they're supposed to do in that scenario. So it's just important to understand that beneficiary designations do override what you have in your will. Those are going to apply first, and then the will kick in to clean up anything where you don't have a beneficiary designation. As I also mentioned, that's going to avoid probate of that specific asset. And so that's where I said, if you have beneficiaries set up on all of your accounts, then all of those assets are going to pass outside of the will, and thus probate will not be required. That court process for your will, at least as to those assets. Lastly, I'll mention that Colorado and many other states now do permit beneficiary deeds, which allow you to actually name a beneficiary of your home, your real estate. For real estate, that can be a valuable tool if you're trying to set up a plan where you want to avoid probate, mostly through beneficiary designations. If you don't have a beneficiary deed, everything else can go through beneficiary designations, but your real estate's going to trigger probate. And I do a fair amount of probates where the house is the only asset. Beneficiary deed allows you to name beneficiaries, take that outside of the will, as well as outside of probate. You have to be careful with a beneficiary deed. There's definitely a list of reasons where you don't want to use one. I don't like to name a ton of beneficiaries in a beneficiary deed, because suddenly you'll have that many people owning a house on death, and 4 or 5 owners of a single house can present all kinds of problems. There's no decision maker like there would be if we had it passing through the will and had one personal representative appointed to help come to a decision as to what needs to happen. There are also issues related to your Medicaid qualification in that scenario if you have a beneficiary deed in place. So there's some reasons not to do it. I really would encourage you not to do a beneficiary deed yourself, but it is an option in Colorado that can be part of a plan that is based on transferring your estate through beneficiary designations. Another common place where things can get messed up is with joint tenancy and joint ownership of assets. So that's another scenario where with joint ownership, if you have 2 joint owners and one dies, that asset, that bank account, for example, is going to go to the surviving joint owner no matter what your will says and without any kind of probate. And so a lot of people don't understand that. They think, well, I'll just add my child on as another joint owner of this account. They go in and do that. Their will says divide everything 1/3 each way, but that child on your passing is going to have no legal obligation to actually go do that because the account is going to be theirs as the surviving joint owner. Joint ownership also applies before any kind of beneficiary designation would kick in. So the point is to just be careful and understand that. You definitely don't want to name a joint owner on any account lightly. It's certainly between spouses can simplify planning, and we use it all the time, but you just need to understand that it kind of trumps everything else. One thing that I always check when folks come in and do estate planning is the ownership of their home. A pretty common mistake, more common than it should be, is for the deed when you purchase your home to say both of your names on it, but not say the key words joint tenants. Or sometimes it will say joint tenants with right of survivorship, or sometimes they just abbreviate it and say JTWROS, which is joint tenants with right of survivorship. That's very useful for married couples who co-own a house. You want it to be joint, you want it to pass easily to the surviving spouse. And unfortunately, if the words joint tenants are left off of the deed, you're both co-owners, but a probate may be needed to transfer to the surviving spouse if the words joint tenants are not on there. So I always, as part of the planning process, pull up your deed, make sure it says joint tenants and that that's what you want. And that way we definitely very easily, in a lot of cases, avoid probate on the first spouse's passing. Another thing I want to just throw out there that we have in Colorado that can cause problems in the context of estate administration is common law marriage. There are lots of misconceptions about what that exactly is. Colorado is one of, at last I checked, only 10 states that even still recognize common law marriage. But basically, common law marriage is really determined when a court makes a finding that marriage existed, even though you didn't go get a marriage certificate from the state. Under Colorado law, that simply requires that both parties agree that they're married. You can theoretically agree to be married, say yes to each other, and orally, nothing in writing, and you're married under common law. You can do that under Colorado law. Problem is that becomes very hard to prove, and it usually only comes up in the context of death or divorce when one party is seeking money that they would not be entitled to if they were not married. And then one party of the marriage is gone. And so it's a problematic concept. There are some reasons that it still exists, but it is problematic. You have to end up producing evidence that there was an agreement. That can come in all forms. A lot of times the first thing we look at is how were you filing your taxes, citing a statement that you were telling the truth under perjury of whether or not you were married. But sometimes it's whether you were calling each other spouse in front of third parties, family members, friends. How are you representing yourself on insurance documents? Things like living together, joint accounts, those have become so much more common between unmarried parties. They don't carry as much weight these days, but they are a factor potentially. Sometimes we look at, was there a marriage ceremony? But the point is that there's always factors pointing both ways, almost always. It's never clear. And you can avoid this issue somewhat by being informed about it, first of all, but making a statement in your will as to whether or not you're married. That usually is enough to clear it up. Now, somebody could come back and say, well, we weren't married when we wrote our will, but we decided to get common law married after that. I go a little bit further if, we're in a scenario where there's, been a long time living together, et cetera, and I say in the will, look, I've been advised that common law marriage exists, I would never agree to that. If I decide to get married, I'll go get a marriage certificate. So that's just another issue I like to point out that causes problems. If you don't have any documents stating whether or not you're married, it can carry some extra problems in Colorado. I've listed some other last few common pitfalls here, and I'll kind of run through this and then probably be pretty close to being ready for questions. Just like I said, a list of common issues. Completing a plan but not reviewing it for decades can be problematic. The goal is to make a plan that addresses contingencies that give us the best result if you don't update your plan. But if major things happen, such as death of a child, death of spouse, even though the document should spell out what happens in that scenario, you might need to update who your personal representative or executor is, who your agent and your powers of attorney are going to be. Those major life events are definite times to review your plan and make sure it still makes sense. Even though, again, we've tried to plan around those various contingencies occurring. I've already harped on this, but creating a trust, not properly funding the trust, meaning your assets at death, for whatever reason, whether they've moved around or whatever reason, are not in the trust. Another error common is only completing a will, but not doing a medical or financial power of attorney to address incapacity. I've kind of harped on that subject as well, but a will is not enough. A will is never going to be enough. In some cases, just powers of attorney theoretically could be enough, but you always want to do that incapacity planning. I'm sure that I've probated estates where we never found the will, even though it existed, because you put it somewhere weird and nobody found it. If we can't find the will, then it's like you don't have a will. In fact, if we can't find the original will, that wet ink signature will, there's a presumption that you destroyed it on purpose. And the result of that is you have no will. So it's very important these days. Most estate planners are going to leave you, the client, in possession of your original document. And you need to put that somewhere that's secure but obvious and communicate that to the person who's supposed to be handling your estate, and probably some backups so that they can find it. I don't advise people to get a safety deposit box just for this purpose, but if you do have one, then that's a great place to put it. That's an obvious place. It's secure. There's a process to go see if there is one and administer it from there. If you don't have a safety deposit box, a safe or a secure file cabinet of some sort is probably just fine. In this community, a firebox is a good idea, although I'll say I heard that they did not survive the 2 huge wildfires that we had here. It's at least something. It's at least an obvious place where you would keep your important documents. So just make sure you put it somewhere good and communicate where that is to the appropriate persons. Another mistake, I'll call it a mistake, some people still do it, is to name co-personal representatives or co-agents on your documents. And what I mean by that is you always want to name a list of succession. Here's my person. If this person can't do it, here's the next person. And here's the next person, ideally. I like to make at least 3 people in every document, if we can and if we have those appropriate people. But there are all kinds of problems with naming 2 persons at once. So I have 2 children. I want to name them both because I don't want to make them mad. And I don't want them to fight over who's in charge. So I name them both. In my experience, that's not only going to make their job practically more difficult, but it's going to cause more arguments and disagreements than if you just had one person in charge. So in limited circumstances, that can make some sense, but generally speaking, estate planners are going to discourage you from naming two or more persons at once to act on your behalf. It just gets more complicated in dealing with third parties who can be instructed in the document to take directions from one person, but they're inevitably not going to do so. Lastly, last thing I'll point out here is just the issue of unexpected descendants. And as DNA genealogy websites become more common, I've had some very interesting unexpected errors pop up in cases, and defining who your children are that you know about and want to include, and their descendants that you know about and want to include, is very important in your documents these days. Even more important, you can close the loop, so to speak, by naming the people who you want to involve in your estate, and maybe avoid the problem of somebody unexpected popping up within the definition of an heir that we talked about within the statutes. So I think that was my last slide. Open to questions here.
We do have some. Do you want to go through them, or would you like me to read them to you?
Pamela, do you mind really quick if we do the door prize in case folks do not have any
Oh,
questions?
that's right. Yeah. Okay.
Thank you.
Okay.
If needed,
Do the door prize. Okay.
great tablet.
All right, so we'll go ahead and do the door prize here. Let me just share my screen. I have a little wheel of everyone's name here. Just give me 1 second. Should be there. All right, so I'm gonna go ahead and spin the wheel, and we'll see who won this prize here. Can everyone see that?
Nate, did you do the little shuffle at the beginning instead of just what? There you go. Perfect.
Let me do a shuffle here. All right, and I'll go ahead and spin this. All right, so Cindy Nelson. Awesome. Cool. She's still here. You have to be present to win. Let's see.
She was. Yeah, she's here.
Okay, great. Cool. So then, Cindy, if you could just email myself or Bree Shalito at njavera, JUVERA @n.com, or bshalito, SHELLITO @n.com, one of us, and we will make sure to get you that $50 e-gift card of your choice. Anything you want to add to that, Bree?
Nope, I'm just putting it in the chat, Nate, for you, Cindy. Congratulations. Thank you so much for joining. If you could just, yes, please email one of us and we will be sure to get the gift card of your choice.
Thank you.
That's great. That's great. Okay. So do you want to do you want me to go ahead with and give you the questions, or did you want to do them yourself, Luke?
I can see them over here in the chat, I think, so I can just kind of run down through them.
Okay.
So the first question I have here is, if you still have a mortgage on a property, do you recommend waiting until the lien holder is paid off before putting it into a trust? And I would answer that I would say no. If we're talking about a standard living trust, and I say standard, there are many types of trust, but types of basic trust that we're talking about for estate planning purposes, where you still maintain control of your property, etc. I'll qualify it with that. As long as you're putting it into your own living trust that you maintain control of, there is not an issue with the lender in that case. Very rarely would they even express any kind of concern. If they did, you are federally protected by a federal law that says you're allowed to do that and they can't do anything about it. And so I guess I would say it's unlikely to even become an issue. If it is, you can point out that federal law and they will leave you alone. But no, you don't want to wait, because you might be waiting 30 years if you're talking about a standard mortgage before you pay them off. And you need to do your planning quicker than 30 years so that you're not feeling the effects of procrastination that entire time. So, no, you don't need to wait. Yes, you can put your home into a trust even if it's still subject to a mortgage. That's the short answer for that. Norman, I think, comments here. It seems that all of us should have either a trust or a will. Many of us probably don't have either. I agree. In fact, the statistic is that less than half of United States citizens ever complete a will. So he's right. Most of us, many of us probably don't ever do it. And yes, you should at minimum have a will. There are, you may engage some other planning that transfers a lot of things outside of the will simply, but you still want to have that will as a backup at a minimum. And, as we talked about, there are certainly cases where a trust is justified. Cindy Nelson asked, what is a formal probate? So formal probate, as I mentioned, informal probate is appropriate and allowable, and I would estimate 90% of my cases. That's informal probate. That's where we typically don't have to have a hearing. The court doesn't have to make any type of formal, I'll call it, findings. Formal probate is required in most cases where we have some kind of issue with the will, as in it wasn't executed properly, or maybe we only found a copy, or maybe the people who are named in the will are still fighting over its legitimacy. I would say abnormal circumstances lead to the need for a formal probate. You can do informal probate even sometimes without a will or with a will. So there's not really a difference in that scenario. It's really a matter of what are the circumstances? Are they outside of ordinary? And if so, a lot of times formal probate is either going to be required or it's going to be a good idea so that the court can make a formal finding as to, hey, where is this property supposed to go? So that's my short answer on what formal probate is versus informal. It's kind of a decision that you make at the beginning of probate as to what's the best way to do it. And in fact, you can switch between the two in the course of administration. So that's the difference there. Norman asked me about programs like Willmaker. And so when I mention making your own documents, I think even using any kind of software these days, and we'll see where software goes. There may come a time in the near future even where the software is as good as I am. I'll just say it. But it's not at that point right now. I can tell you that for certain. And I think if you use Willmaker, I'll say the same thing I said describing somebody who's making the will on your own. And this applies to any kind of software. You're probably going to get a valid document produced. The question will be, did you think of all the contingencies? And does it actually say what you think it says? And I think you run into those same problems with software that you do with just scrolling it out yourself without any kind of guidance. So that's what I would say about Willmaker or any kind of software. It's probably better than nothing, but I've definitely had wills that I wished didn't exist. We would have been better with nothing. So you just don't know. But that's all the comments that I see. I'll hand it back over to Pamela, unless anybody has anything else.
Are there any other comments or questions? This will be recorded, as you know. So she wanted your contact information. Can we get your contact information? I know that was on your original slide, but if you want to repeat that again for the folks.
That's on the very first slide. I can type it in here. My phone number is 719-362-0698. And my email, which I'll also type in, looks like I accidentally just sent that to Bree. I'm gonna try that again. Okay, so I just put in my phone number and my email. It's just luke@lukejlaw.com. So again, that's Luke, J as in Johnson, law, LAW.com. And I put that in. And
Great.
my office is downtown on North Tejon.
Great. You'll be getting a follow-up email for those of you who have participated. You'll be getting a follow-up email with a list of the upcoming webinars that we have in the Reframing Retirement. And you'll get the opportunity for a very short survey. If you would be so kind as to do that, we'd greatly appreciate it. I do see another question here. Do you see that, Luke?
Yes, Norman just asked, how often should these documents be updated? And I would say this, I would say anytime there's a major life event, it would be good to take them out and look at them yourself and see, oh, was that the person that I had selected to be in charge of everything who's now deceased? So, if there's a major life event, a lot of times, addresses, name changes are not that big of a deal that would justify updating your documents for that purpose. So certainly any kind of major event, just as a general rule, I don't think it needs to be done every year. I don't think even every 2 years is necessary. But maybe every 5 years is what I tell people. You ought to be at least thinking about your plan, pulling it out, looking at it, see if it's updated based on how things have transpired over that time period, as well as check your beneficiary designations on your accounts. Make sure the whole picture is still kind of in order. So that's generally where the number I throw out is every 5 years or so. Should be adequate, but certainly with major life events, take a look at it.
Okay. Luke, should it cost very much if you need to update your will? So say after 2 or 3 years, you need to update it, but it's not a life-changing event. It's just some things that you wanted to update in the will. Should that be an expensive proposition with the lawyer, with the attorney?
Usually it's going to be less expensive than the original will. When I do an update, it's usually less than half of what the original charge was to update it. And to do an amendment, it depends. Sometimes the changes are such you probably should just start fresh so that you're not dragging around an amendment along with the original document. But in a lot of cases, an amendment is just fine. And yes, that is going to be more affordable and cheaper. Or the answer may be, and I give this answer all the time, no, you don't need to update your will just because your one of your beneficiaries got married and their last name changed. We still know who we're talking about when they're referenced in the will, and it's not worth the trouble of doing when this is still going to be legally valid. So definitely a question worth asking, but yes, generally speaking, it's going to be less expensive.
Okay. Thank you. Anybody else? I like what you said here, George. You can't go back and change the beginning, but you can start where you are and change the ending. I like that. That was by C.S. Lewis. That's great. Well, you've given us a lot of information today. It's been jam-packed. That's great. Hey, George. George was our winner last week. Yeah. Well, unless there's any other comments or questions, we'll wrap it up, and I hope we see the rest of you at our other events that are coming up. And did Ent want to say anything more, or are we good?
Just echo the thank you, and thank you all for joining. And yep, every Monday, 4:00, except for the holiday, please join us right back here.
Okay,
Thank you.
all right. Thank you all. And Luke, thank you so very, very, very much. Appreciate it.